when OSHA knocks on your door, will you be ready? I'm Mike Latif, and I'm the co-chair of our business litigation group. With me today on the panel are Richard Blake, who's our co-chair of our white collar and government compliance practice, Adrian Steeman, who's an attorney in our labor and employment group, and Don Orlandoni, who's an attorney in our business litigation group. We'll be happy to answer any questions that you have. Please just write them down on the note cards that are provided. Hold them up. Somebody will come around, pick them up from you, and at the end we'll cover them as time permits. If you're joining us from the webcast, please just click on the email link that's provided, send your question in, and again, we'll try and get to as many of those as we can, time permitting. We'll be done at 1 today. If we don't get to your questions, we will address them on our business advocacy community following this presentation over the next few days. So thanks again, and hopefully you enjoy the program. What to do when OSHA knocks on your door? It's a topic that we think and we hope is important to you, but from a starting point, when you're getting ready for OSHA and the inspection steps you can do to plan for it ahead of time, Richard, why don't you tell us a little bit about what an employer can do to prepare for that eventuality that may and often does occur?
Okay, thank you, Mike. Welcome, everyone. I was in the government for 20 years, so I'm going to ask you to do something, is to put yourself in the shoes of an OSHA official. Much of what I talk about here is, I think, is common sense. And although we recognize that all of your businesses have different characteristics, some smaller, larger, multiple departments, single shop, at least from my aspect, much of this, again, is commonsensical. And I ask you to put yourself in the shoes of these folks. They're generally good folks. I know that when we deal with government regulators, our first thoughts are, oh, heck, here they come to interfere with our business. OSHA inspectors see themselves, and they are, good people. They're here to ensure the safety of our workplaces. We all have different experiences with the way things actually work out, but this is their mindset. Most of the people I know in the regulation have never been in business. So their views are more or less focused on the regulations themselves. And we could talk amongst ourselves, being in business, how they get in the way, how they're somewhat obstructionist, in the views. But they are there, we must deal with them. So again, you put yourself in the shoes of an average inspector, and you just ask, what would it look like if they were to come in? And I wrote down here, the key to do everything reasonably necessary to prevent an inspection. 2 types of inspections. Complaints, which are by far the most common. Employees, people who have come in, or a random inspection. You don't have any control over a random inspection. They show up, they show up. But the word that I have is culture. And I'll say this whether it's in a hospital, whether it's a mechanic shop, a large corporation, is the culture of the organization. You must, and this is nothing legal about this, you must make employee safety the highest priority. We all want to make a profit, but we can't have it be looking like we're putting employee safety second to making profits. There's always a balance there. But if you go about everything that you do with the idea of employee safety, I believe, at least in my experience, you're more than halfway there. For example, having an accessible first aid kit around. There are places that don't even have that. Someone gets hurt. Having that, again, take the culture seriously. Communications with employees. Again, you're running a business. Many times these are 18-hour days for most people who are running these things. But that's not going to matter if you have employees who don't believe that you take their safety seriously. So one thing which we talk about, if you walk away with anything here, it's just the fact that you have communications with your employees. You want employees to believe, not just by just a simple. You want them to believe that you're listening to them. Again, common sense. If this was so easily, if this was followed by everybody, we would not be having this talk today. It doesn't happen as often as it should. So you discuss it with employees, you let them know that you take it seriously, the safety. You have a suggestion box, as simple as that, even if it's a box out there, even if it's just OSHA rules and regs, or which they provide to us. Having a suggestion box, depending upon the size of the organization, having a committee. I mean, there's always those folks who are safety conscious. You say you're going to be on the committee. If you are a larger organization with multiple departments, you take someone from each department. Again, as we talk about it, it seems somewhat commonsensical. Yes, it takes time. It's another committee. But if you're dealing with an OSHA inspection a year and a half later with an employee who doesn't feel that he or she was listened to, and you're sitting across a table from a regional administrator with the federal government, and they're talking about these fines and mitigations and all the effects that could have on getting loans or getting contracts later on, you're going to say, I wish we had had that darn committee a year and a half ago. I have a written safety program and an OSHA log. And again, not to do it in a flimsy manner, but truly, you have and again, the panel is going to go into more details about the specifics of this. But as I'm talking about, before we even get there, to prevent this, you don't want to have a complaint filed against you. And ultimately, as I wrote down for myself here, communication is the key. OSHA, or as any regulatory agency, is more likely to mitigate issues later on if they know and they believe that you've actually taken all reasonable steps, to do it. You don't want to have someone with their iPhone taking pictures of spills or broken banisters on railings and complaining about it, and you do nothing about it and send it to OSHA. Because even if you get it fixed up at the time, they ask you, well, what about the banister? You say, ooh, goof. We don't have any problems with the banister. Now you've potentially made a false statement to a federal official and they got photos from your employee's iPhone. It's a new world that we live in. And so, I mean, it's just as simple as that. What's very important, which I have found, is you have to have a protocol for dealing with OSHA, for dealing with inspectors. And what does that mean? Well, specifically, you want to assign one, and you'll hear about this after in more detail, and two, so not just one, but one main person to be the contact with an OSHA inspector. For whatever reason, if they show up, you don't want to have the receptionist there saying, hey, come on in and just walk around without the proper protocol. You definitely want to have someone trained basically in OSHA regs. They don't have to be an expert on that. But they have to generally know what the rights of an OSHA inspector are. When they come on site, they have rights. They could be there. You're under their thumb in that way. But they're not in charge. I mean, they even within their own field office manuals will say, if we show up and there's, again, a receptionist there, and they say, well, the boss isn't in yet, they're supposed to give you time. I think, as I was just reading last night, it's at least an hour or more. So they have to be reasonable. Because you may have a facility with a lot going on there. You want to have a person who's trained how to deal with these people, the person with the right type of attitude. And if that person's name is Jane, and Jane's not available that day, you should always have a backup person. And again, if it never happens, if you never have to use their skills or have to deal with it, that's great. But it's like having insurance. You have to have these, or you should have these things. You do whatever you think is right. But if you don't have it, I guarantee you later on you'll wish that you had. You want to have, again, if you leave here, if you just do this, you'll be ahead of the game. You have someone who will be the contact person for an inspector. You have what we call a little OSHA kit. What's an OSHA kit? It's like, oh, they're here, know where to go. You should have a camera in there. Now we have digital. You don't even have to worry about having film or anything like that. Just something that's plugged in with a battery that works. Because when an OSHA inspector goes around, they're going to take photographs. If you've ever been through these, they take photos. They make their own notes. Not only are you entitled to, you'd be foolish not to be right next to that person taking photos along with them. And for every one photograph they take, you take 5. You want to be able to address it later on. They're not out there, and again, at least in my experience, to harm or to lie about anything. But when you're looking at a picture, a photograph 4 months later, and you're asking someone else who was not on site at the time to make a determination, and you say you have a particularly aggressive inspector, you're relying on their photos. And then you got to rely on them giving you copies of their photos. If you have your own photos, you're already ahead of the game there, so you can ask. I mean, you may have a violation, but at least at least you'll know. I tell people to have a pad and a pen or a pencil in there too, because once someone comes in, people generally, this is out of their norm. This is not the normal morning now. They're walking around and you're getting names thrown at you, issues. You want to have someone who's got a cool head with a pad. You want to get people's contact information. Don't ever let anybody from the government come into your facility without them giving you a business card. Ask them for it. I mean, it's like if you have kids, going back when the doctors come in and you let these physicians and people all look at your children, then you try to explain to someone later, well, who looked at your kid? I don't know. I mean, it's just human nature in that way. So that's sort of your little checklist for your person. May I have your business card? Let me tell you, if an inspector comes into your business without a business card to identify themselves, you've already got yourself an issue, in my opinion. And it's not because of the sequestration that they cannot afford business cards. It's just that the way that they, and again, they're good folks. They're there to do good work. But if they're sloppy, you need to know about it up front. You also psychologically, I believe, put someone knowledgeable saying, I'm dealing with a facility that knows what they're doing. I can't be flippant with them. And never, ever, ever, I mean, when you train your people, be rude. They have a right to be there, whether you like it or not. They have a right to be there. And so you always be polite. And again, however inconvenient it may be. I wrote here, no need to be confrontational. I should have changed that with a big capital, never be confrontational. There's no need for it. I also, to end on this, again, just you go out there, you go back to your business today and tell them, clean it up, be diligent. I heard someone talking about why one company, McDonald's, was so successful. They said the philosophy was the job is to consistently clean the place. Now, occasionally someone will come in and ask for a hamburger, and then you stop cleaning and give them a hamburger. But go back to cleaning. And years back when McDonald's started to take over, the biggest selling point for that company was that it was clean. People could, instead of going into a greasy spoon, they went into a business that was a place where they didn't mind taking their families. I take that idea to your businesses as well. You should be consistently cleaning. If you were in the Navy, you remember they used to yell at people to clean and swap. Do it because that will also add to the culture of your facility. And again, depending upon the type of workplace that you have. Outdated equipment, obstructed walkways, visible waste spills. These are items that are easy to clean. They're easy to ignore. Again, you look at our houses, most of them, unless you're married to someone who's just a clean freak, they're messes. And once you start seeing it after a while, it just becomes acceptable. I've got work to do. We'll take care of that later on. I suggest that that's something that we could look at and make it a quick fix. Because you don't want people taking pictures of it and going to OSHA with a complaint. Because in these extreme cases where there are, and we'll talk about it later on, willful violations, or just an ignoring of it, don't worry about it, we'll take care of it. All it takes is a particularly savvy or aggressive employee or anyone to take a picture, and I use your iPhone, Android, whatever you have, and then to have that, they have that picture there. That's a violation, even if you clean it up later on. And then OSHA comes in and says, hey, what about this? Now you're stuck saying, oh, do I tell them I never had it? How do I know that there's not a photograph out there? It's again, you do this basic, keep it clean, good communication with your employees, and I think that, again, from my personal experience with it, you're way ahead of the game, and it's a lot easier to deal with these people later on in case they do come in. Because inevitably, again, based on my experience, everywhere you go is going to have an OSHA violation.
Thanks, Richard. Yeah, I think the takeaways are, as Richard pointed out, be proactive. Don't wait for OSHA to show up before you decide we need to address these issues. We need to make sure we have programs in place, safety programs. We need to have a plan where when they show up, who's going to deal with them. Like you said, it's our suggestion to you, have a compliance safety officer, depending on your size of your company, maybe even a committee, who's prepared, who knows what to do when they show up, who's contacted immediately to go deal with them, address them, bring them in, and sit down and go through their steps that they've been trained on. One of the items that Richard said was, you know, the make it a top priority of the company. We all want to be profitable, but make it a top priority. I guarantee you that the cost of training, the cost of putting a program together, if you don't do it and OSHA comes in, would be a lot less than the violations, citations, and fines that you'll get. It's money well spent up front to get that done, and a lot less than you might spend ultimately down the line if you don't do it. So, as he said, I think it's very important that you get proactive and you deal with it up front. So what is OSHA's purpose? Why do they come to your place of business? What are they looking to do? Don, why don't you tell us a little bit about what OSHA's purpose is and what they're looking to do and why they can come and what reasons will they be there to show, why would they show up?
Thank you, Mike, and greetings, everyone. It's a pleasure to be with you today. I think it's no secret that OSHA claims to serve several objectives. Perhaps the purpose that we're all familiar with is to ensure a safe and healthful workplace for American working men and women. So the question becomes, how does OSHA serve that purpose? And OSHA does that in a number of ways. One is to enforce the workplace safety and health standards that fall under the OSHA Act itself, as well as the corresponding federal regulations. Another way is to maintain and require covered employers to maintain a reporting and record-keeping system for workplace injuries and illnesses. And the reason that OSHA maintains that requirement is because there's also a research and development component to OSHA. OSHA mines the data that the covered employers keep on an annual basis. And that's what drives OSHA's determination of which activities are creating the most risk in the workplace. And it also aids OSHA in determining which industries OSHA identifies as being high hazard industries that might warrant further attention from OSHA. OSHA also does provide some training resource services. It is possible for an employer to contact an OSHA area office. For example, in Ohio, there's an OSHA area office in Cleveland, Cincinnati, Columbus, and Toledo, but they would provide consultation services. The general OSHA website is also very informative. OSHA also works hand in hand with states. As some of you may know, the OSHA Act allows each state to pass its own set of workplace safety and health regulations. And for the states that do that, those are the standards that apply as opposed to the OSHA federal standards themselves. Now, there's often a striking similarity between the state plan and the OSHA standards, and that's because, as mentioned, the state plans are developed in consultation with OSHA. OSHA has to approve those state plans. As it stands today, there are 27 states that have developed their own state plans. Ohio is not a state that developed a state plan, nor is Florida. So OSHA standards apply in Ohio and Florida. Illinois is an example of a state that does not have its own OSHA or safety regulations that govern its private employers. So the OSHA standards apply to its private employers. Michigan, the great state of Michigan, which is my home state, has enacted its own legislation for private employment, and so in that regard, the federal standards don't necessarily apply. Now, in terms of the specifics of why OSHA will show up at a particular workplace, obviously OSHA can't visit every work site each year. And so what OSHA's done is it's created a priority list, and that's what the administration uses to determine when, why, and in what order OSHA is going to visit different workplaces. The top priority on the list is the imminent danger. And as the name suggests, an imminent danger in a workplace arises when there's a reasonable certainty that a dangerous condition is going to cause death or serious physical harm. And in this context, serious physical harm means permanent or prolonged damage to a person's body, or it could mean an injury that requires inpatient hospitalization. So when OSHA gets word that there's an imminent danger in a workplace, that's going to take top priority, and OSHA is going to come out to that workplace to make sure that that situation is being addressed and is not likely to cause the harm that's at risk. A second tier priority involves fatalities and catastrophes. Fatalities are self-evident. If a worker dies, the employer is required to report that to OSHA within 8 hours. OSHA will then come out to the job site to investigate whether the death was the result of an OSHA violation, and of course to ensure that whatever caused the death has been corrected and won't create further risk. In conjunction with that, there are catastrophes, and a catastrophe is defined as an incident in the workplace that causes 3 or more workers to go to the hospital to receive treatment. If OSHA gets wind of that, again, the employer must report that within 8 hours. OSHA will come out and investigate. Now, the legislation on that is going to change so that a catastrophe is very soon going to be defined as any situation in the workplace that causes 1 or more worker to go to the hospital. So the regulation is going to be tightened up from that standpoint. The next level of priority, which is the #1 reason why OSHA comes to a workplace, involves employee complaints. Under the Act, any employee is allowed to contact OSHA and to make a report as to what that employee perceives to be a potential safety risk in the workplace. And the employees that do that are afforded protection under the statute to protect them against any retaliatory activity that the worker might take. Along with the employee complaint is something that's called a referral, and a referral is basically a complaint that comes from another source, not from an employee, but quite commonly it could come from another federal agency such as the Department of Health and Human Services or the Environmental Protection Agency, whose representative, while visiting your work site, might see something that looks suspicious from a safety and health standpoint. That person will contact OSHA. OSHA will then come to the scene to investigate the situation. Below that, on the scale of priorities, are the high hazard programmed inspections. And if you're a fan of Seinfeld, these are kind of the pop-ins. And really what drives those inspections are the survey material that OSHA compiles based on all of the reports and records that the employers keep. From that material, OSHA determines which are the high hazard industries. If your workplace falls within that industry for a given year, OSHA may very well target your workplace as a site or a location that it wants to visit. And then below that, in the last tier of priorities, is the follow-up inspection. And I think that's also pretty obvious by the name itself. If OSHA comes out, conducts an inspection, and cites an employer for 1 or more violations, OSHA could very well return to ensure that the employer has taken the appropriate measures to abate those violations.
Thanks, Don. Just to summarize a few things there, based on my experience of having dealt with OSHA for many, many years now, I would say approximately 80% or more of the situations where OSHA shows up are based upon a complaint of an employee. In certain instances, if you're working in a construction setting, for instance, and you have multiple employers out on a work site, you have multiple contractors, you have inspectors, it may be a competitor, it may be one of the other contractors for another company who issues the complaint. So that is the typical instance where OSHA is going to be showing up, and usually they're going to have a list of complaints that have come to them that they're there to specifically review. Of course, once they're in the doors or on the site, then everything's game. They can look at basically everything in your facility within certain bounds that we'll talk about in a few minutes. But once they're there, they're looking for any safety issue. So that's the typical scenario. I've seen instances, however, where an OSHA inspector's been driving down the street, seen a construction site going on, decided to pull over and just look at it and did an opening conference, showed up, and started issuing citations. So it can happen at any time for any reason, but the predominant one is the employee complaints. So when OSHA comes, they knock on the door, they show up. What are your rights as a company? What can you do at that point? Hopefully you have your compliance officer or somebody designated to deal with them. What are your rights and what can you do? Adrian, tell us a little bit about that.
Well, I would just touch briefly on the 2 people that you're going to train to be OSHA's greeters, right? You want person one and person two to both be in management. Typically, your first choice is your environmental health and safety person. They're most likely the person who can walk in and look through and see whether or not we have any big issues, right? And the reason we have two is because chances are EHS guy Don is going to be at a seminar, sick, or on vacation when you have the misfortune of OSHA showing up. That's why you need his sidekick, John, who also happens to be in management and hopefully has some training that'll help him walk with OSHA. The first right that always comes to mind when people talk about OSHA is OSHA's the government, so it's subject to the Fourth Amendment. That's your searches and seizures, law and order moments, we want warrants, things like that. I will tell you that out of the four of us sitting here, probably none of us have ever recommended someone demand a warrant. It would be an extreme situation where a warrant would be something that we would recommend. A, they can get it quickly, and B, when they get in the doors, they're now mad at you, right? They think you have something to hide, and they're going to look extra carefully at your facilities. I have heard, and I haven't had the situation come up personally, that some clients or employers have had luck requesting, stating to the OSHA officer, our attorneys advised us to contact us anytime OSHA comes in. We are happy to comply, but will you just afford us the time to contact our lawyer? Now, I will tell you, if you have the opportunity to buy any time, you're going to want to do whatever you can quickly and discreetly and quietly during that time. This is not a time to do a run through panic because your employees will rat you out. But it is if you notice things that you can quickly abate. That's the time to take that step.
Okay, and what is the process then when they show up at the door? Typically, it's not with a warrant, and absent exigent circumstances or something very big problem within the facility that you need to protect against. You invite them in, you're polite to them, you have them come in. What do you do from there?
Well, the first step of the process is the opening conference. OSHA's required to do it. I've never heard of the CO coming in and not doing it. If for some reason you feel like they're getting right into the inspection, you're going to want to request it, because that's essentially your planning meeting. That's when you find out why they're there, what the scope of their investigation is going to be. If there's a warrant, you want to make a copy of it. If there's a complaint, it'll be redacted, obviously, but you want to make a copy of that too. That's also when you're going to start taking detailed, fact-based notes. And when I say detailed, I mean you want to know what time they came there, who came, who's at the meeting, what they've told you the scope of the investigation is going to be, what they've told you what regulations you're going to fall under, who they want to talk to, what parts of your shop they want to visit. Because that's going to essentially lay out your plan for the next day or days, depending on how much they want to see and how much they want to look at.
What rights do they have once they're in your facility to inspect the facility, to take their photographs, to take whatever measurements they have? Tell us a little bit about, from an employer standpoint, what you should do if they want to do those types of activities.
Well, they absolutely have those rights to do those things. What right we have is that we have the right to have somebody from management present, right? And the employees also have the right to have somebody from representing the employees present. But from an employer standpoint, what we care about most is that EHS person or that management who falls into number 2 is always present during the inspection. This is also when the kit that Richard mentioned earlier comes into play, right? We have our camera, we have room on a disk on that camera, we have a backup disk, we have a backup battery, because OSHA might not wait for you. If you're working in soil and you have to take soil tests, you have the apparatus to do that. If you need measuring tapes, I mean, depending on what kind of business you're in, these are things that you want to have handy for when that inspection starts. And the reason that's so important is because you don't want the only evidence to be the evidence that OSHA's obtained, right? So what that means is if OSHA measures, you measure. And if you come up with something different than the CO, that's the time to share it. Because once they've issued the citation, it's a lot harder to change their mind that that was not the case, right? As Richard said, if they take a picture, you take pictures. Because OSHA's going to take the picture that looks right to them. But we want different angles. And if your picture you think shows something that maybe the CO didn't notice, that's the time to point it out, right? You think that there's not, the guard isn't right. But if you look at it from this angle, I think that it's the way it's supposed to be. I mean, these are the time that we should make those assessments and make those comments, nicely, obviously not adversarially, to the CO before they issue their final reports.
And just to highlight an example of that, I've had companies that I've worked with before who've had OSHA come out to their work site. In a particular instance, it happened to be an excavation trenching situation where excavation had been dug. The OSHA inspector felt that it was a serious violation. There was a substantial probability of harm or injury to employees. He took his photographs and in fact went down into the excavation to take his measurements and to take his photographs. And our guys who were prepared and savvy took photographs of the inspector down in the excavation, taking those measurements and photographs. And when the citations came around, it was time for appeal, we laid out those photographs and said, well, if he thought it was such a substantial probability of likelihood of death or injury that was going to be suffered by an employee, why in the world would he go down there and take pictures and measurements? And that really backed him off and changed. In that case, it was in Michigan, so it was a state plan. Say OSHA's attitude on that violation, and they backed off. So that's just one example of why you want your own documents, your own evidence, your own measurements, because pictures are two-dimensional, and you may think you see an angle, or you may think you see guarding on a piece of equipment that is an inch or a half inch short based upon what they're telling you. But when you do your measurement, it's not a half inch off. It's right. And you want to have that to be able to respond to any violation that you have or that you receive later on. Employees that can the OSHA inspector talk to employees of both the managerial level and at an hourly or lower level in the company?
Yes, they can. I mean, obviously, if it's in the rare warrant situation, that's something that would be in the warrant. But again, that's not typically the field that we're playing in. What I would note for employee interviews is your employees should be aware that they can have a member of management present, right? They can also have, if they're part of a union, their union steward present. I would say for management employees, what your management employees need to know is you want to request to have your attorney there, because management can bind the company by their statements. So that's important. And regardless of management or non-managerial employees, they have the ability to review their statement. And when you review your statement, just like everything else, every other piece of evidence that OSHA's taking in, if that statement is wrong, that's the time to tell OSHA, that's not what I meant, that's not what I said. And then one other thing that I thought of when you were talking, Mike, don't tell on yourself. If you see something when you're walking through the OSHA officer, don't point it out, even if you can quickly fix it. It won't get you brownie points. They'll put it in the report. No good deed goes unpunished.
So your employees do have the right, and you should make it known to them that they have the right to have you there if they want. If they choose not to, then they also have that right. OSHA can meet with them privately, can talk to them privately. And the OSHA inspectors, typically in my experience, are going to put some pressure on them to talk to them individually, to segregate them, because they'll think they'll get more candid, more honest answers from them if management's not sitting there with them in the room. So there's nothing you can do at that point if they choose to go that route other than to demand a copy of their written statement. Typically, OSHA inspectors will not give you a copy of that written statement. They will assert a privilege. It's called the informer's privilege that protects the identities of employees who either file complaints or who make statements. At some point down the line, if you have to get there, you can get those statements, typically in a redacted form, so you won't see the name. But in my experience, again, once you get them in a redacted form, it's pretty obvious and evident who the statement was made by. Obviously, the laws are such, and nor would we ever recommend any type of retaliation. That could get you in a bigger problem with the court system. But that's what it's set up to protect, and why they don't give you those statements and won't give you anything but a redacted statement until much later down the line in the process. So, thanks, Adrian. Let's talk a little bit about the OSHA inspectors' rights. We've touched on a few here, but what are some of the rights that they have once they enter your facility, whether it's voluntarily or with a warrant in the rare instance? Don, tell us, what can they do? What is their rights and what can't they do?
Sure, Mike. Talking about the other side of the coin, and Adrian alluded to several points that apply to the compliance officer during the inspection process. So I'll try to minimize redundancy as much as I can. But having said that, unfortunately, let me start by being a little bit redundant. And that is really, from the inspector or the compliance officer's viewpoint, the inspection starts as soon as he walks into the facility or onto the work site. And What's very important is that the employer have something in place to handle the arrival of the compliance officer. For example, if the compliance officer shows up and is made to wait a long time before being put in touch with a management representative, that can have inevitably an untoward impact on the rest of the inspection, at least from the employer standpoint. So the inspector's going to be looking at the inspection as something that begins as soon as he hits the door. Now, as to the opening conference, as Andrea mentioned, the compliance officer should lay out the purpose and the scope of the inspection, should tell the employer which areas of the work site or the facility he's going to inspect, which records the compliance officer is going to review, whether there are going to be interviews of the management personnel or private interviews of the employees, and he should also give the employer a sense of which OSHA standards apply specifically to the inspection. He's also going to ensure that there is a management representative in place to escort him during the actual inspection tour. There's no obligation that the employees have a representative, although they certainly can. But often, if the employees do not have a representative on hand, the compliance officer is going to be more inclined to stop for impromptu interviews along the way and talk to employees who may happen to be on the work site and ask them whatever safety-related questions he deems appropriate, and then it's kind of at the employee's whim in terms of how he or she will respond to those questions. During the inspection tour itself, really the compliance officer has a great deal of discretion in terms of time or the route that he takes through the work site, the duration of the inspection. The only real constraint on the compliance officer is reasonableness. He can't show up at the work site at an unreasonable time. The duration of the inspection can't be unreasonably long, and he cannot conduct the inspection in an unreasonable manner, which basically means that he can't do anything unduly to interfere with the workers on the job site, or more generally, the workflow itself or the progress of operations in the plant, whatever that may be. But he's certainly going to walk through and he's going to take measurements. For example, if it's a health inspection involving hazardous chemicals, toxic substances, the inspector is likely to take samplings to ensure that the work environment is safe for the employees. Photographs are certainly fair games. The inspector can basically talk to anyone he pleases, and along the way he's going to point out, most likely he'll point out, any violations or unsafe conditions that he sees. For example, if there are blockages in the aisles of a plant that create unsafe conditions, or if there's an unsafe floor surface, or if there's a protrusion or projection that creates a danger in the workplace, he's going to point those things out to the employer. Another thing that he's going to do throughout the entire inspection process from the beginning to the end is, through questioning and through reviewing records, he's going to gauge that employer's safety and health program to ensure that it's comprehensive and that it's actually enforced within the workplace. And that's why it's so important for the employer to develop that kind of a program and to ensure that he has people who are smart and knowledgeable to execute that program. From an optics standpoint, having people on hand who understand the safety protocol at a given place of employment is another factor that could kind of set the tone for the inspection. And it might even shorten the inspection. The inspector might be less likely to go into certain areas to investigate, provided that it appears to him that he's got employees and management personnel on hand that understand safety and that have a commitment to safety. The inspector is going to review records, as I mentioned. There are some basic forms that every employer is required to maintain on an annual basis under the Act. One of those forms, and I understand that they may be hardly visible here, but one of those forms is the Form 301, and all of these forms are available on the OSHA website. but this is basically an incident report. So each time there's an accident in the workplace, the employer is required to fill out this form. Richard alluded to the log and summary of occupational injuries and illnesses, and this is kind of a centralized compilation of all of the workplace incidents that take place throughout the year. The compliance officer is going to want to see this and make sure that the employer is keeping this up to date. There's also an OSHA poster that many or all of you may be familiar with, but this is a poster that OSHA requires to be displayed in a prominent location at a work site, and a prominent location is somewhere that employees often pass through or an area where employees often congregate. And this poster really does nothing more than very generally and in skeletal fashion lay out the employee's rights and obligations and the employer's rights and obligations under OSHA. As mentioned, part of the records, if the employer has a written safety program, certainly the compliance officer is going to want to review that. Also, he's going to review any written protocol as to the hazard communication procedure in the employment place. If something happens in the workplace, or if there's a dangerous condition, is the architecture in place so that that hazard gets communicated effectively and efficiently up the chain, and then gets abated or corrected as soon as possible without causing an injury in the workplace. So those are all things that the compliance officer is going to be looking for or considering during his inspection tour. At the end of his visit, there will be a closing conference, and the closing conference is mostly an opportunity, as Andrea mentioned, for the employer to have a free and frank discussion about anything or everything that the compliance officer observed during the inspection tour. The employer can ask about specific standards if the compliance officer indicates that there was a violation. The employer can ask about specific standards that apply to that violation. And it's also the employer's turn to make sure that he fully understands what the inspector's takeaway points are from the inspection. And also there might be some discussion during the closing conference about abatement. And I would caution, and excuse me if this is something that was already covered, but I would caution the employer that when it comes to setting abatement deadlines, because that's going to be a dialogue, the employer is going to have some input on, insofar as there have been violations identified by the compliance officer, the employer will be able to suggest deadlines. I would only caution that the employer be very careful not to box him or herself into an abatement deadline that's impracticable, because it doesn't give the employer enough time to make the correction.
Okay, couple of summary points there that you mentioned. First of all, they will typically, when they show up, ask you for certain documents. The OSHA 300 log is the log that Don referred to. That's a typical document that they're going to want to see. They're going to want to see how many injuries have been occurred over the last several years. That's something you are required to keep up and keep up to date. Once a year, you're supposed to post a report based on another OSHA form in a public place that talks about your lost days of work, and there's a number of factors in there. They want to make sure that you're following that obligation and posting that information up on a yearly basis. It doesn't have to stay up all year, but it has to be posted once a year. They're going to want to see your safety program. Hopefully you have a written safety program that you can provide them. But any written safety program is only as good as it is enforced. We can have all the programs in the world, but if you don't follow it and you don't pay attention to what it says and seek enforcement of it, it's not worth the paper it's written on or the cost you spent in providing it or preparing it. Okay? Most safety programs have, and one of the things that an OSHA inspector will look for is a disciplinary policy of enforcement. If you have an offender or an employee who's not following the rules, have you followed your program in terms of what you say you're going to do to that employee? Typical, and not all of them, but a typical one may have a 3-strike policy. First strike, you give a verbal warning, you document it in their personnel file. Second strike, you write them up. You make them sign it. You say you violated this second time, you have it acknowledged, you put it in the personnel file. Third time, if they continue to do it, that is subject to, at the employer's discretion, termination of that employee. they are going to want to see if you have an instance of a violation and you claim that that was employee misconduct. You've trained that employee, you've told that employee, you've made sure that they're aware of that regulation and what they're supposed to do, and they continue to not do it, they're going to ask you, have you followed your policy? Have you verbally warned them? Have you given them a written warning? And if so, why are they still here? Okay, so you want to have that later on if that is in fact the case where an employee has been trained and they haven't done what you've told them to do. A defense that is available to you to any violation is employee misconduct. But you're going to have to prove that. And those documents and those warnings are the way you can prove it and avoid being responsible for a violation if an employee truly was trained and just simply wouldn't comply. So the last point I wanted to mention, Don mentioned the closing conference. And this really applies throughout the entire time you spend with that inspector. It's a time to listen. You're not there to offer or educate that safety officer on every aspect of your business. Okay? You want to listen, you want to answer the questions. If anybody's ever been involved in a deposition, same kind of principles apply. Don't offer information, only answer the question that's asked. Make sure you document what question's asked and what the answer you gave is on that notepad that Richard talked about. Okay? You're not there to offer more information. I've seen many circumstances when an OSHA inspector comes in, sits down with a management person who is not aware of what their rights and responsibilities are, and starts giving them chapter and verse on all the things that are wrong with the plant and all the things that they intended to do but never got around to it. You know, business was down, we just didn't get to it. It's going to take us another year to get that done. Guess what? They don't care. That comes back around, and you're going to get that citation because you didn't do all the things that you knew you had to do. And money isn't an object to them. The fact that you didn't have the money to do it isn't going to matter. So my overall point is don't admit that you have problems. Let them determine what your problems are and cite them. And you just listen, take notes, and be prepared to respond when the time is right. Okay? The time isn't right at the closing conference. So I've also seen circumstances where comments have been made at closing conferences. Next thing you know, those verbatim words are right put into the citation. So-and-so said X, Y, Z. And once X, Y, Z is down on paper, you have a real hard time refuting it if you did say it. So I caution you on the open and frank discussion. Obviously, you want to be polite. You want to answer the questions that are asked, but you don't want to offer or give too much information because it can come around and cause you more problems later on down the line.
Or I think what I always tell people is if somebody asks you, did you have breakfast, the answer is yes or no. It's not, well, I had a great piece of toast and some bacon and then eggs on the side. Right?
That's exactly right. So one of the questions that we've received and one of the topics that I wanted to touch with you is what are the emphases of OSHA? What are the current emphases? What are the most citations that are being issued in terms of the regulations? Which ones are most strongly emphasized? And then what industries and areas are they focusing on? I think I'll get into specifics, but in general, they focus on those industries and those regulations that are in the areas of work that can cause the most serious harm or the most serious injuries and or fatalities. So in terms of the top 5 or 10 citations, what you'll see are things like scaffolding regulations. You know, when you're working on a construction site or in a painting situation or on a bridge or on any type of scaffolding that's erected within a facility or outside a facility, typically that's where you see the most violations of any citation that's out there. It's the number one citation because people scaffolding can stay for a long time. It's not monitored on a regular basis at times. You put it up, you think it's all good, and then you never check it again. A week later, 2 weeks later, things get loose, things happen, and next thing you know, you're in violation. And hopefully it's not, you don't find that out because somebody falls or because there's an injury or a death. Fall protection, very similar. That's number 2. It's a very similar concept. You have to tie off. If you're working from any height of any significance, you have to make sure you're hooked in and that you're tied off and complying with that regulation, that you have the proper harnessing equipment, the proper personal protection equipment for that job. That's number 2, and again, it's because they do see a lot of injuries, they do see a lot of falls that unfortunately happen because people don't comply with those regulations. Hazard communication, and I tie that to hazard communication programs and respiratory protection. Those are 3 and 4, and they're really, in a lot of ways, tied together. Hazard communication has to do with dealing with chemicals, either fluids that you can come in direct contact with, airborne exposures. There's defined regulations for most chemicals, almost all chemicals, as to what the time-weighted average is that an employee can be exposed to. They wear, there's testing that's done, patches are worn. They're going to want to see that you're doing that testing and that your time-weighted averages are less than the allowable ppm, parts per million, or whatever the measuring category is. Respiratory protection, again, if you have a situation in your facility where people are exposed to chemicals, they want to make sure you're giving them proper equipment, respiratory equipment, confined spaces. Those are, again, areas where we see a lot of citations and a lot of injuries and deaths, unfortunately. Similar to that, lockout, tagout. Any of you that have manufacturing facilities or work in manufacturing facilities, I'm sure are familiar with that concept. If you're working on a machine, repairing it, maintaining it, you have to lock it out. In other words, de-energize it so it can't be inadvertently activated. You have to tag it to make sure it's clear to anybody that's going to work on it that it has been de-energized and when it was de-energized and initialed so that they know who did it. Okay? History is replete with instances of inadvertent activations, people walking by, bumping into buttons that weren't deactivated, and somebody's working in there, and you can imagine the horrific consequences that can occur on machines that exist in I'm sure some of your facilities. So those are ones that have special attention paid to them. Machine guarding, again, same reasons. If you have guarding that is required by regulation to protect against people getting limbs, appendages, cuts, bandsaws are an example, but any type of equipment where you can get an injury and guarding is required, you have to make sure that guarding is compliant with the regulation. And they can cite you for things that guarding is a 1/4 inch off or a 1/2 inch off, as I referred to earlier. So it's important that you make sure that you have A, followed manufacturer guidelines with guarding, and B, that you followed OSHA regulations with guarding. Electrical power sources, that ties in again to the machines. Make sure that you have all your electricity is up to code. All the boxes, electrical boxes, are marked properly, because even a situation where you have everything's working fine, but you don't have a sign or you're not marked according to what it needs to be marked under the regulation, that's a serious violation. Okay, and you're going to get written up for a serious violation in those instances because the consequences can be so dire under those circumstances. So those are the violations we see. What industry focuses are there? The typical industry focuses tied back to what we see in the violations. Manufacturing operations is always a target. Has been, it's been on the emphasis, the special emphasis program of OSHA since the 1980s, and I don't think it's ever left, and I doubt if it's ever going off of that list, okay? So if you're in the manufacturing field, sooner or later, OSHA will be at your facility. You can count on it. It may take a year, it may take 10 years, but they'll be there sooner or later, okay? Construction, that is a very, another high emphasis. In fact, there's a whole set of construction industry inspectors whose whole focus is to deal with construction sites, construction projects. Excavation is the biggest one that they look for. Are you digging your excavations properly? Are you cutting back the sides? Are you using shoring, trenching equipment to properly guard employees who have to get down into those excavations and work without threat of being caved in on? Machines that are used, backhoes, loaders, trucks that come on, where you pile the dirt you take out of an excavation, how close it is to the hole. Those are all things that we see multiple and repeated violations on, again, because the consequences are so dire if they're not followed. The newest one that's been added this year is the nursing and residential care facilities. That has become a new emphasis of the current administration, and we're going to see a lot more inspections and I'm sure a lot more citations coming out of those facilities. Why? Well, principally because there's been so much activity in that area. You're building a lot of care facilities, nursing homes over the last several years. Our population continues to get older. There's more demand for those. So as a consequence, as they pop up, OSHA's out there because they've seen an increase in illness, sicknesses, and injuries. They've documented those over the last several years, which led them to emphasize it. Exposure to bloodborne pathogens in those areas. Chemical exposures that are used within those facilities. Workplace violence. It's a very prevalent area, for whatever reason, for workplace violence. So they have really heightened their scrutiny on that. And if you're in that space, you should really get your I's dotted and your T's crossed now to prepare for it. Because again, whether it's a year, 2 years, 5 years, OSHA's going to be visiting you. So those are the industries that we see. Chemical is always a big one. The particular chemicals they look for: hexavalent chromium, lead, silica. Those are the typical ones. If you have those in your facility, you're going to be a target. You're going to be somebody who they're going to look to find. So hopefully that answers and addresses the questions of what is highest on the priority list. Just because you don't fall into that category, don't assume that you're not going to have OSHA coming out to see you, though. Those are just the higher risk areas, if you will, for visits by OSHA. Richard, we've talked about what happens in an inspection. We've talked about the closing conference. And by the way, you don't necessarily get the citations at the closing conference. In fact, it would be rare to do so. OSHA has 6 months from the time they close with you, the date they close, to issue a citation. So anywhere in that 6-month period of time, you could get that citation delivered, mailed to you. Don't think because the closing conference goes and 3 months goes by and you forgot about it, that OSHA's gone away. They haven't. Look for your mail. If they go outside the 6-month period, then they have a problem because now they're untimely, and at that point, you have a very good chance of not having that violation on your record. Mm-hmm. But tell us about the types of violations and penalties that OSHA has at their access to issue when they find violations. Okay.
And we have a number of questions, so I'll go through these 4 types of violations. OSHA, they've broken them down. First, they've broken them down into willful violations, serious violations, other than serious violations, and repeat violations. The first, without a question, the worst, which you don't want to have, willful violations. And I have it written down here. It's easier if I just read the way that they have it. Defines a willful violation as one that is committed intentionally, despite clear knowledge of OSHA regulations. These are the kind of regulations where you have to deal with OSHA, but you're probably going to get sued by your employee as well. Where you clearly know what the regulations are and you discard them. And if someone gets hurt, you've got more than just the government to have to deal with. They carry a minimum penalty of $5,000 per violation, upwards of $10,000 per violation. And they have an adjusted multiplier of up to 7. So it could be up to $70,000 per violation. Now, they're determined by the financial, the penalty is determined by the type of willful violation, the specific violation in question, a previous history of violations that the company has had. Again, it's going back to the culture and what we talked about earlier. And again, what we've tried to talk about, it comes full circle, where if you start off with what we talked about earlier, the chances of you having a willful violation are nil. There's serious violations. These are defined as violations which present a considerable likelihood of death or serious physical harm for employees, and those in which the employer is also aware of the dangers. Those are serious. Violations up to $7,000 per incident, though the penalty can be reduced if the employer has made good faith attempts to correct the issue, or if the employer has no history of previous violations. So a little bit less. Other than violations, defined as violations which are not life-threatening, but nonetheless present a danger to employee health and job safety. Again, $7,000, up to $7,000 per violation. Again, you can mitigate this with good faith correction efforts and your past history. Again, with regards to past history, there's the 4th, repeated violations and failure to abate. And these are violations which have remained uncorrected since the last inspection. OSHA will give you a date to abate a violation. It's something that you can normally work. It's a good faith, reasonable time. If you do not abate it at that time, in addition to the amount of violation in question, which can be up to $70,000 per violation, if you don't do it by the abatement date, that's another $7,000 per day, every day after the abatement date that you don't do. So that's what you're facing with this organization.
Thanks, Richard. We're running tight here. We've got about a minute left. I want to address just a few questions, and I'll try and do it quickly that have been raised. Can OSHA respond to an inspection that occurs based upon an ex-employee's complaint? The answer is yes. OSHA is going to respond to a complaint if they feel it's serious enough. They're going to come out and inspect whether it's an ex-employee, a current employee, a competitor in certain circumstances, another contractor on the job. There's any number of scenarios where they could. What is your opinion of inviting OSHA Office of Compliance Prevention for a review and mock inspection? We may vary on this amongst the panel. My general advice is I get very hesitant to invite OSHA out to your work site. One, it gets you on the radar if you're not already on it. Okay. Two, while you're exempt from any inspections or citations while you're there, and they may spend 30 days pointing out issues to you, recommending things to you, and you're exempt from any violations. Once you're off, again, you're on their radar. If they come back out, history's gonna, your knowledge and history is going to be assumed at that point because you've been trained by OSHA on the issues, especially if you violate the things that they cite. Others have different opinions, and they think it's not a bad idea to bring them out. That's my general advice. My suggestion is if you need help with training, contact your work comp employer or work comp insurer. I know in Ohio the states is that, but in other states they have private insurance companies. They often will offer presentations. They'll send somebody to your place of employment. They'll help you train. They'll give you handouts. They'll give you materials. Contact a consultant or an attorney who's experienced in it. They can help you set up your program. They can review your program. They can give you advice. They can review your facility and give you recommendations. So that's my general advice on that. Lastly, and then we'll wrap up, is the rule being tightened to require an OSHA inspection if one or more person goes to the hospital or more than one. It's going to be one. That's the legislation right now. I expect that it's going to be passed sometime this year and go into effect. If one person goes to the hospital, you're going to have to report. Right now, it's a total of 3. If 3 are injured and go to the hospital, then you have to report to OSHA. But they're tightening that up. I want to thank you all for the time and joining us today, both here and on the web.
Can I have last comment? Is that like if they get admitted to the hospital, if they go for just treatment like stitches or versus a med center, or is that?
If they go to the hospital and are addressed by the ER, and whether or not they're admitted overnight, if they go to the hospital for treatment, and it's 3 people that go,
Right, but with the new legislation.
it's going to be the same. It'll be only one person this time.
But not if they go to an urgent center or.
No, correct. Like a Concentra or something, no, it wouldn't be. Thank you very much. We will, for those of you who asked questions we did not get to, either in person or on the webcast, please visit our business advocacy community, which is available through our website. We will be posting the questions and answers to them over the next several days. Again, I want to thank you all for your time.
Thank you.